Uh, Good evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for today's event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Anil Malhotra, sir, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Code Practice, Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy among different groups of society under the vision and direction of Patron Chief of Sambhav Initiative, Honorable Justice C.K. Thakur sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about child custody and guardianship. It is my privilege to introduce our distinguished speaker today, Mr. Anil Malhotra, sir, a renowned advocate practicing in India with an illustrious career spanning over 40 years in Indian and international family law. Sir holds a Bachelor of Science and Bachelor of Laws from Punjab University, Chandigarh, and earned his LLM from the University of London in 1985. His legal education includes specialized studies in comparative family law at the London School of Economics and Law and Society in South Asia, University of London. As a fellow of International Academy of Family Lawyers and secretary of its International Child Relocation Committee, Sir is globally recognized for his expertise in cross-border family law issues involving NRIs. His expertise includes complex matters of surrogacy, inter-country adoption, child custody, parental child removal, marriage, divorce, guardianship, maintenance, and enforcement of foreign judgments in India. Sir has acted as amicus curiae in over 35 constitutional cases and rendered over 150 expert reports on Indian family law to foreign courts and institutions. With appearances before courts across India, including the Supreme Court, Sir has argued over 1,000 reported cases and advised extensively on issues involving conflict of laws, nationality, succession, inheritance, and international child education. Sir has also authored and co-authored 10 authoritative books between 2005 and 2025 on topics related to family law, private international law, and rights of global Indians. Sir has penned over 1,500 legal columns, delivered 155 webinars and lectures regularly at premier institutions including National Judicial Academy and National Law Universities. His expertise, scholarship, and advocacy have had a direct impact on policy formulation in India. We are deeply honored to have you with us today, sir. Over to you, sir.
Good evening, everybody. Thank you for inviting me to this platform, which is very informative and very educative. And I am delighted to be here to speak to you on a very important topic relating to child custody, guardianship, and related issues concerning a very important area of law in which the information is quite scarce, but law has evolved through judgments in most of the situations, which is up for interpretation in different matters before courts in different periods of time. Now, first of all, the concept of guardianship under the personal law, that is Hindu Minority and Guardianship Act, and the secular law, the Guardian and Wards Act, is basically a concept to be understood because these are the only two laws under which this synchrony takes place between these two legislations. Now, unfortunately and sadly, our substantive law, which is a secular law, is found in the Guardian and Wards Act, which is a very antique colonial and an archaic act of 1890. We did make the Hindu Minority and Guardianship Act in 1956, which was a law applicable to personal law applicable to Hindus by religion. But the act in itself clearly says that it is an act which is in addition to and not to expressly override or be derogatory of the Guardian and Wards Act. And the Guardian and Wards Act is the provision under which you can invoke a court of jurisdiction of a court of law. The Hindu Minority and Guardianship Act does not contain any provision to independently lead you to a petition for guardianship and custody. Now, before we really go into the visions of the Guardian and Wards Act, let us first see what is the terminology and what is the phraseology in the terms stipulated in the Hindu Minority and Guardianship Act. So, first of all, it is applicable to people who are Hindus by religion. That is primarily very clear. And as I just told you, it is to be read in conjunction with the Guardian and Wards Act. Now, the guardian is a natural guardian or a court-appointed guardian, and the conditions laid down for guardianship are relating to guardianship. They do not provide issues relating to custody by way of a statutory remedy. Now, a natural guardian is obviously in charge of the child, taking care of the child, having rights and ownership over all his issues. Now, the Hindu Minority and Guardianship Act empowers a city civil court to take cognizance of issues relating to a child, but then the substantive remedy to move the court itself is in the Family Courts Act or in the Guardian and Wards Act. And Section 13 says that the paramount consideration for the appointment of a guardian or by care and control of a minor will be the best interest in the welfare of the minor. So, Section 13 prescribing that the welfare of the minor shall be the paramount consideration, and Section 8, the powers of the natural guardian, have to be read in conjunction to say that whatever is to be done for the benefit of the minor. Now, let us move to the provisions of the Guardian and Wards Act. Now, the appointment of a guardian under the Guardian and Wards Act is a provision available to people of all religions, people or a parent or any third person other than a parent, by virtue of the procedure laid down under the Guardian and Wards Act of 1890. Now, the Guardian and Wards Act of 1890 stipulates that it is to provide for appointment of guardians, and the word guardian is defined as a person who can be a parent or who can be a person other than a parent. And obviously, again, the power of the court is when a guardian needs to be appointed in the best interest and welfare of the minor. Now, anybody who is a relative of the minor, anybody who is desirous of claiming guardianship of the minor is entitled to claim guardianship. Now, let me just twist things a little to explain to you how is this provision used in terms of interparental child custody conflicts. So whenever there is a conflict within India or there is a cross-border conflict between parents, one parent who has custody of the child by virtue of being in India or by virtue of bringing a child from abroad when the other party is living abroad or the matrimonial is abroad, comes to the guardian judge, which is the family court or the civil court, if there is no family court, and seeks appointment of her or himself as sole guardian of the child and seeks sole custody. Now, there is a form of an application laid down. And there is a principal provision in Section 9 of the Guardian and Wards Act which says that the petition for the guardianship of the minor shall be filed in a court where the minor ordinarily resides. So, unless and until the minor is habitually and ordinarily residing within the jurisdiction of the court, the civil court or the family court, the petition for guardianship would not be maintainable. So, simply removing a child from the custody of another parent in another part of India or outside India will not give custody rights of moving the court under the Guardian and Wards Act petition. Now, under Section 12 of the Guardian and Wards Act, the court has the power to make interlocutory or interim or for the time being orders for the custody of the child till the matter is decided finally by the court. So a parent can get custody to the exclusion of the other parent by virtue of an interim order during the pendency of the petition. Now, Section 17 again comes in, like Section 13 of the Hindu Minority of Guardianship Act. Section 17 of the Guardian and Wards Act says that for the appointment of a guardian under the Guardian and Wards Act, the prime consideration will be the best interest and welfare of the minor. And Section 17, subsection 3 also says that if the minor child is old enough to form an intelligible preference, the court shall consider the option of the child and speak to the child and interact with the child and will know it. Section 19 says that if a parent is to be appointed as sole guardian, the other parent has to be declared unfit or incapable so that the other parent can get exclusive custody. It's a pretty tough provision, but that is the way it has been built. So this is the backdrop of the statutes under which the guardianship provisions have been laid down. Now, there have been inroads into the law by India signing the United Nations Convention on the Rights of the Child. Once India signs an international convention, India is per se obliged to make provisions in its domestic law for giving enforcement, for giving teeth to the provisions of the convention, which are incorporated in the Indian law. So, upon India signing the United Nations Convention on the Rights of the Child, we made changes in many laws, the Right to Compulsory Education Act, the Juvenile Justice, Care and Protection of Children Act, and many other statutory laws to give benefits to the rights of children. Now, the changes which came place in the Juvenile Justice, Care and Protection of Children Act 2015, the most important definition which came in was under Section 2, subsection 9 of the Juvenile Justice Act, in which the best interest of the child was defined. There is no statutory provision in any other law in India, codified or uncodified, where best interests and welfare of the child is defined. And the Juvenile Justice Act is not confined to orphan, abandoned, or surrendered children. It is confined to children whose rights are at risk, whose rights have been violated, who are at risk, and so on and so forth. So, broadly speaking, if you have the best interest and welfare of the child to be determined in a custody petition, the judge has to look at not who is a better parent, who has superior financial capacity, who has better amenities, better facilities, but how will the best interest and welfare of the child be determined. Now, this is a very tough job because in our family law jurisprudence, we have not built a process by which we have statutory provisions to to determine the best interest and welfare of the child. It's a totally discretionary, it's a totally open proposition. And the Family Courts Act provides that any petition pertaining to the custody guardianship of a child under Section 7 shall lie before a family court. So, any suit or proceeding in relation to guardianship of the person or the custody of the minor or access to the minor under Section 7 will go to a family court. Now, the family court is bound to make endeavors to make settlements. CPC and Evidence Act don't apply, and the court is free under the Family Courts Act to take legal representation, allow, disallow lawyers, have a legal expert, have an amicus, or have a child-friendly lawyer. But the fact of the matter is that the voice of the child is by and large unrepresented. My experience has taught me that a child custody petition is more of a case where a child is social currency. It is only a war, it is only a feud, it's only a difference of opinion between the parents. They may be very good guardians, both of them may be excellent parents. But they may be bad husbands or bad wives. The faults lie on both ends. But is a guardianship petition, is a custody petition a case to decide who is a better parent? Is the child a trophy to be awarded to a parent who has more money, more influence in terms of fiscal wealth and living standards? No. The child is not a trophy to be handed over at the end of the litigation. You may make the child miserable. But sadly and unfortunately, our statutory provisions do not have any mechanisms whereby there are mandatory provisions for doing or taking things up in a separate way. The Legal Services Act, counseling, mediation are all available. But in effect and in practice, they become unworkable because the matter ultimately goes back to the court. Mediation probably most times does not resolve the matter, and the fights are so bitter that the children end up in what Justice Sikri has described in Vivek Singh versus Romani Singh, suffering from parental alienation syndrome, meaning the child gets to know one parent or stays with one parent for so long that the child becomes polarized, becomes alienated towards the other parent, and doesn't want to know the other parent. So that animosity is extremely damaging for the mental health of the child. Now, this is seen more vigorously in issues and conflicts arising from interparental child custody disputes from foreign jurisdictions. You marry in India or you marry a foreigner abroad, you have a child, you have children, you undergo a bitter divorce, you start fighting on custody. There are marital and custody proceedings in both jurisdictions, one abroad, one in India. There is a clash of jurisdictions. And courts don't oblige each other's orders. Now, in this context, I would like to bring in a convention which is called the Hague Convention on Civil Aspects of International Child Abduction 1980. It is signed by 110 countries. India has not signed it. So, if a parent removes a child from a foreign country in violation of one parent's rights or in violation of a foreign court order and brings the child to India, the other parent follows with a court order of that country. The parent who has brought the child to India moves the family court or the civil judge in a guardianship petition seeking sole custody. The Indian courts do not automatically implement the foreign court order. And there is no remedy under the Guardian and Wards Act, the Family Courts Act, or the Hindu Minority and Guardianship Act to go into the merits or demerits or implement a foreign court custody order. So what happens? The matter is taken up in a habeas corpus petition under Article 226 before a High Court or under Article 32 before the Supreme Court. And the Supreme Court or the High Court adopts a jurisdiction known as parens patriae, meaning overall guardian of the child by virtue of the child being in its jurisdiction to determine the best interest and welfare of the child. So the court, by way of a summary proceeding through affidavits or hearings, tries to resolve the matter and tries to adjudicate on the rights of the parties. And if the court finds that no, there is a severe violation of the rights of the child, the High Court or the Supreme Court normally tends to return the child. But this is again a varying jurisprudence. Sometimes the court say yes, sometimes the court says no. It's a total discretion of the court. Now, this concept how it goes back to as old as Gohar Begum, 1960 Supreme Court, page 93, where Supreme Court said that following English law, the habeas corpus petition is not to determine the illegal custody or illegal detention. It is it is aimed to protect the welfare of the child. Now, of late, this concept has been firmly embedded by the Supreme Court in Tejaswini God, 2019, 7 SCC 42, Lahari Sakhamuri, 2019, sorry, Tejaswini God was 2019, 7 SCC 42, Lahari Sakhamuri is 2019, 7 SCC 311, then Vasudha Sethi, 2022, All India Supreme Court Report of Criminal, page 279. Now, in all these three judgments, the determining factor for the maintainability of the habeas corpus has been by saying that the welfare of the child is the paramount consideration before the court. The court is not going to implement a foreign court order for the asking. Foreign court order will be only one point of consideration. The illegality of the detention is not going to be an issue. Parent is in the custody of a child. So there is no question of illegal or illegal detention. So the determination is on the welfare. This concept has also been very well coined in Rajeshwari by the Supreme Court in 2022, Rohit Thamanna again 2022. And ultimately, the Supreme Court, by and large, instead of relegating parties to a bitter custody dispute under the Guardian and Wards Act, is taking upon the role itself of saying that it is in the best interest of the child to go back. Now, there is also a principal judgment of the Supreme Court given in 1984 by Justice Chandrachud in Surinder Kaur, where the Supreme Court said the jurisdiction which has the closest contact with the child will determine the welfare of the child. Which means that if the child is removed from a foreign jurisdiction, that is the country which has the best infrastructure to determine the best interest of the child, because the child has grown up in that acclimatized atmosphere. The factors determining his welfare are all there. Now, this principle of jurisdiction of closest contact has been consistently followed over the years and is still good. And this, coupled with the best interest and welfare doctrine by the Supreme Court in its wisdom, is a best interest. But then the larger question is, should our High Courts and Supreme Court, in their extraordinary jurisdiction under Article 226 or 32 of the Constitution, be deciding child custody disputes? Where are we lacking? What has gone wrong? We have gone wrong because we have not changed the statute law. Report number 257 by Justice Shah by the Law Commission, recommending serious changes in the Guardian and Wards Act and the Hindu Minority and Guardianship Act, is pending since 2015. We need to empower our courts by statute, and we need an empowered family court judiciary and maybe a family court bar to work on these problems. We are 1.4 billion now. About 35 million live abroad in over 110 countries. Our global travels, cross border marriages, intercultural conflicts have multiplied. Our system in the family courts is not geared to handle all this. The statutory provisions are what is before the family court or the civil judge. He is a creature of statute. He can't travel beyond what is written in the statutory laws. There is no updation in terms of judgments. For a family court to decide everything, there has to be basis, there has to be evidence, there has to be procedure, there has to be a petition. The family court can't become a constitutional court and start using extraordinary jurisdictions without recording evidence. It would go fall flat. In Aman Lohiya versus Kiran Lohiya, Supreme Court said it. It said that the procedure has to be followed. This was a very interesting case where a child had been taken away by the father to a foreign jurisdiction and various things were done. And meanwhile, the mother had moved the family court to be transposed as the petitioner in the guardianship petition which the father had filed. And the court had allowed it, and in a very summary way, it had, without recording evidence, granted the custody to the mother. And the Supreme Court said this can't be done. There is a procedure to be followed. There has to be a petition, there have to be pleadings, there has to be evidence. Now, for this procedure to go on, we need serious amendment in our statutory laws. Now, this brings me to the next proposition of where are we in terms of shared parenting and joint custody. Now, shared parenting and joint custody are concepts which don't find mention in the Guardian and Wards Act. It is of 1890. Obviously, it won't. The act is too old to have encountered all this. But we haven't done anything in the Hindu Minority and Guardianship Act. So it is a wisdom, it is a discretion with the court to balance these equities. Now, Savita Sitaram, AIR 2020 Karnataka, 372. Tushar Bale, AIR Bombay, 2016 Bombay, 88, are two basic judgments in which shared parenting, joint custody are concepts which are finding mention, and they are sought to be advocated to be followed as a principle in generality. You see, the child is not a commodity or a table or a chair that it has to be kept by one person. The child needs both parents, as Justice Roshan Dalvi has said in her judgments. What does family mean for a child? It means father F and a mother M, I love you. So the word family has been interpreted very well by the judge. But it is the family court which is to understand this. That the determination of the welfare is best in the interest of the child. So things like both parents having access, both parents having joint custody, both parents participating in the welfare of the child is what is known as what appears to be the ideal situation. But what is the reality on ground? The reality on the ground is whoever has physical control or physical custody of the child deprives the other parent of all rights of access, custody, visitation, and so on and so forth. And the child is at times so badly alienated, polarized, or full of venom or vendetta against the other parent that the child refuses to see the other parent. And this brings about to a total flouting of the orders of the court. You can't force a child to go with a parent if the child is very badly poisoned. That is why Justice Sikri in Vivek Singh versus Rumani Singh has very clearly said that unless and until there is a level playing field between both the parents, giving a child custody of a child to one parent is meaningless. Determining the best interest and welfare, you need the child to be open minded, the child to be amenable to both parents is the fundamental principle before you can decide the final custody issue. But where is the time? How will this happen? Is a slow process. Now, Kerala has done very well. Justice Mushtaq and Justice Dias, in a very innovative judgment, have laid down a scheme of appointing a child independent lawyer through a scheme of the legal services under the National Legal Services Authority Act, and has made the Kerala Legal Services Authority in charge of the scheme, and has asked the infrastructure of the State Legal Services Authority to provide panels of child independent lawyers so that the child has a voice. This has happened in Bombay also, in the family courts in Bandra. And this is a concept which really needs to be advocated. So you need to have a lawyer who will speak for the child. A child custody petition is not a divorce petition. That brings me to the fourth part of your address: drafting of custody applications and visitation rights. I have assisted many courts as an amicus, and I find that a petition for custody in a habeas corpus, or maybe even a Guardian and Wards Act petition, the contents of the petition are a replica of what is said in the divorce petition. So what is done is the entire contents are transmitted. You talk about how the other parent is such a bad parent, how cruelty has been suffered, what desertion has resulted, what adultery has happened. There is no mention of the child. How are you a better parent? How is the best interest of the child subserved? It's not an issue. In all countries abroad, there is a concept of shared parenting. There is a concept of joint custody. Meaning thereby, you don't talk of solitary or single custody in the hands of one parent. You talk of shared parenting, you talk of joint custody. Now, the issue is when a child is sent back, let us suppose in a custody petition or in a habeas corpus petition from India to a foreign country, there is great reluctance that the spouse going back, invariably the mother, will be put to rigorous legal conditions. For example, in the US, violating child custody is a federal offense. So you can go to prison. In India, leave alone civil, criminal, it is not an offense at all. Because under the Hindu Minority and Guardianship Act, the custody of a child, a minor child, shall ordinarily be both the father and the mother are natural guardians, and the custody of a child less than 5 years of age shall ordinarily be with the mother. In Lahari Sakhamuri, the Supreme Court has watered down the concept of less than 5 years or more than 5 years with mother or father. But the fact of the matter is that parents are natural guardians. So if a child is removed by one parent, no offense is committed. It's not a civil offense, it's not a criminal offense. You can't say my child has been kidnapped because the father or the mother is a natural guardian. So there is no question of offense. Now we fall foul with foreign jurisdictions which consider this offense as a wrong. But we don't consider it as an offense at all. So there is a big problem on these issues. I belong to a fellow organization called the International Academy of Family Lawyers, exclusive fellowship of family lawyers all over the world. We have committees running the organization. There is a committee on international relocation of children. I'm the secretary of the committee currently. We have compiled data of all the countries in the world through members to contribute to making a policy. I attended a meet in Washington. It was the 15th anniversary of the 1980 convention. And I attended a meeting with 100 experts from all over the world in the Embassy of Canada in Washington. And we were a isolated country because we do not follow the principle. We have not joined the convention. We don't respect each other countries' orders. So we have a very ad hoc system. It works well. I This is what I have to say to the world over, that at least our superior courts, that is the High Court and the Supreme Court, they do a marvelous job in resolving these issues. And justice is very effective, but it takes time. So the process is slow. The remedy is there: per case hearing, individually heard, determination of the best interest by superior court judges. It's a very fine process, but our courts, our constitutional courts, have no time. They are very busy, they're overworked. As it is, the number of petitions of other characters under the constitutional laws are are are, are increasing every day. So the long and short of it is that we need a major overhaul in our child custody and guardianship laws. We need to seriously relook at our provisions relating to custody and guardianship. We have done a wonderful job on adoptions. India has signed the Hague Adoption Convention of 1993. We have Central Adoption Resource Authority in place. Inter-country adoptions are taking place. There is a legitimate process. We need to replicate this process in terms of child abduction also. I was a member of Honorable Justice Bindal Committee, where this committee was constituted by the Government of India. I was an amicus in the case where a child had been removed by an aunt. It went on for 12 years. I was assisting the court. We couldn't bring the child back despite CBI going and trying to bring the child back. So I gave a report, and the Honorable Judge, hearing the matter, referred it to the government. Law Commission gave a report, and a committee was constituted with 6 honorable judges, government officers, and myself. We did a voluminous job. We came out with a 3-volume report. We recommended a bill to the government in 2019, but we are where we are. And so we are before Sambhav Foundation today in a summary of what I have done in almost 35 or 40 years. I did my first child removal matter in 1986. Child was removed, didn't go back. Child vanished. A roving writ was issued. Matter got resolved after a long time. But then we are where I was and where we are. So, Dr. Kapilesh, it's back to you for questions which people may have, and I'm willing and open to answer any questions which any student or any lawyer or anybody has.
Yes, yes.
Uh,
Thank you very much, sir.
Thank you so much, sir.
Yes, Amit, over to you.
Now we open the floor for question and answers. So there's one hand raised. So you can unmute yourself and can raise your question.
Good evening, sir. Very good evening to you.
Yeah, I can hear you. Can
Sir,
you
sir, this is Sumit.
Yeah, go on, but speak a little slowly because your
Uh,
voice is coming through is a little breaking up.
yes, sir. Like, sir, I wanted to ask from you, like, there is in adoption, there is a rule that a male person cannot adopt a baby girl, but a female can adopt a boy. So, is it that in case of custody, in case of custody, the female, the mother is always given. For example, I heard in the news after divorce of Malaika Arora and Arbaz Khan, Malaika Arora to get the custody of the son, and the father Arbaz Khan to have visitation rights. And sir, what exactly is visitation rights? Means the other partner has a right to visit child anytime, anywhere, any. What exactly? What are the conditions when you get the visitation rights imposed by the court on you? And is it true that the female spouse get preference over the male when it comes to the when it comes to the custody of the child?
You see, now, first of all, let us be very clear. There is no statutory provision deciding how visitation rights, how access, and how interim provisions of contact, etc., are decided. It's all a discretionary process. Now, you must understand that I have labored a lot in explaining to you that whatever is to be done, it has to be in the best interest of the child. Now, first of all, I can understand that there is a gender bias, that the female child should go to the mother and the male child should go to the father. But I think this concept is slowly being now done away with, because in Justice Khanwelkar in Lahari Sakhamuri has said that there is no rule, there is no statutory bar for a female child less than 5 years of age going to the father, and more than 5 years of age going to the father. This is There is nothing like this. So this gender bias is, the glass ceiling has been broken, and this uh, division on male female, I don't think is a very good idea in the best interest and welfare of the child. Coming to the second question. Now, the court has to lay down time, date, place for video contact, for personal visitation, supervised, unsupervised. So the court order lays down this is how it is to be done. But 9 times out of 10, it is violated, it is infringed, and it is not observed. So you keep fighting more, you disturb the child more. So there is no system in place for enforcement. Would you like a parent who's violated the order to go to prison or be punished? No, it's not in the interest of the child. But for parties to understand this is very far fetched. Invariably, the child is used as a weapon to settle scores with the other spouse. So this makes the custody, visitation, and access a failure. That is the reality on ground. Next question, please.
Next, Arun.
Good evening, sir. Thank you very much, first of all, for explaining it so well. And sir, I have just a question, sir, that a lot has been asked about this parental alienation, and we also saw a lot of uproar about this parental alienation and shared parenting. And do you see any hope in the future for the laws to be changed? Because as far as shared parenting is concerned, and as far as the current situation of law is concerned, if the child is residing with one parent, then there is a lot of chances that there lot of poisoning, social poisoning is there, lot of polarization is there. The child mind is so polluted, and a lot of time I have also seen the court has also commented. Means treating the child as a commodity in order to get the maintenance done. A lot of times the court had said that you pay so much of maintenance to the parent who has the custody of the child, and then only they will grant the visitation rights. So is it in the best interest of the child? And do you see any basically light that that we are on the right track of things?
You see, let us first understand that the man at the grassroots level, the judge, the family court or the civil judge, he is an authority or a court who is lettered with provisions of law. He has to follow statute law. He is not a constitutional court judge that he can tweak the law and make changes here and there. He has to read down the provisions. So unless and until we amend the act and bring in shared parenting, joint custody, and shared access, as report number 257 by the Law Commission has advocated, we will reach nowhere. We have to revamp our law. You may bring guidelines, schemes, mediation, so on and so forth, but it's only ad hoc, it's only stopgap. And after that, you need sensitive family court judges. You need the court to think on the child. You need to look at the child. You don't need to look at the husband and the wife. But again, family courts are overworked. We need a lot of family courts. Family courts need to develop very fast. I live in a place which is a modern city, the city of Chandigarh, with a very high divorce litigation, very high child custody litigation, but we don't have a notified family court, which means that a civil judge deals with the custody petition. If there is a matrimonial divorce petition, it goes to the additional district judge because the district judge sends it to him. So we haven't even thought of building abled, strong, well-lettered family court judges. Then we don't have a family court bar. A district court lawyers fraternity handles everything. People don't specialize because one has to do everything to survive. It's a difficult way of life. So we actually need to change a lot of things. Unless we change the statute, we have an empowered family court structure and we have dedicated family law lawyers. I think we'll keep going like this and we'll leave it to the constitutional courts. Thank God we have constitutional courts because I assist courts in some jurisdictions and the courts do a marvelous job. You have no idea how good these High Court and Supreme Courts are. Next, please.
Uh, Anand, sir, you can unmute yourself and ask your question.
Good evening, sir. Thank you very much for such a nice piece of information. I have one question. Like you said, the need of hour is shared custody. So, what is stopping us from reaching there?
Stopping us, Parliament has no time to amend the law. If report number 257 is waiting since 2015, 10 years have gone by. Why is it gathering dust in the shelves and the archives? Change the law, amend the law. You can do it in respect of laws which bring in money. Look at the Arbitration Act. Look at laws concerning revenue or fiscal issues. They get amended so fast. Family law is a low priority. Nobody's got time, nobody's got interest. See, the parliament, it's the law minister or the council of ministers or somebody very empowered in the family law structure, in the Ministry of Health and Family Welfare, Law Ministry. These are places which need to seriously look at amending the law. So maybe people listening here will start doing things, practicing things and advocating things, and the fire will spread. I've been doing it for 40 years. Now the baton is in your hands. Next question, please.
Akanksha, you can unmute yourself.
Um, Hi, can you hear me?
Yeah, I can hear you. Go on, please.
Hi, sir. Thank you for sending me this link. I contacted you earlier. I'm in the UK right now. I know you remember. I think you remember my case a little bit.
Let's come on to specifics, please. Put your question to me, please.
Yeah, it's just that I attended this and I can see how different it is in India. And I'm all up for the idea of shared parenting, but I have a relocation case going on because I want to come back to India, and my husband is opposing it, and he's also not supporting me financially, so I cannot stay here. Obviously, if he doesn't support me, and I have no option other than coming back. So yeah, it's a bit complicated, but we already have some shared kind of arrangement. So like the baby visits him 3 times a day or like for 6 hours and alternate weekends overnight. Do you think in such case there is a possibility of relocation? Because here, as you know, they give priority to contact with both the parents, which is obviously right. And Yeah, I have also mentioned that my husband is from India, so he can relocate to India. He has lived his whole life in India, so I don't see any problem. Why can't he? When I can, where I can be forced to live here, he should be able to relocate too if that is so. Yeah, I'm like really it's a big conflict, like whether this would be successful or not.
See, you can approach the court in England. Are you in UK now?
Yes, I have a relocation case going on, and I have told
But
them
you
like.
have to satisfy the court that if
Yeah, that's best interest of the child, that if child comes back to India.
you have to satisfy the court that if the child goes to India, the child will be brought back. Assurances, guarantees, support systems. It can be done. You can
Hmm.
also promise that you have access, custody, fairness, alienation. It needs follow up. It needs perseverance. The point is because we are not a signatory to the Hague Convention on Child,
Yeah.
India is not a favored destination for judges abroad. I give
Yes.
It's telling the court that if you do this, we can do it. I am currently handling a matter where there is an issue like this. One
Okay.
lives in one country in the world, or the other parent is in another country in the world. The one of them has one of them has Indian roots. They are separated.
Mhm.
They have decided the child wants to be with both. So the child comes to India, and my office representative in Delhi, through me, uh, keeps the passport of the child and
Oh.
keeps contact with the child. And when the child is to go back, the passport is when the child goes back. It has worked 3 times. So you have to you have to devise, you have to strategize, you have to manage, you have to work up solutions, and you have to uh, convince the court in that foreign country that the child will come back.
Mhm.
Next question, please.
Thank you.
Thank you, sir, for your time. I have one question. Like in Atul Subha's case, the grandparents sought the custody of their grandson, but the court termed them as an alien to the child. How can such a view align with the principle of the child's best interest?
You see, let us understand. There was a case of Neil Ratan Kundu, where the father was convicted for murdering his wife, that is the mother of the child, and the child was very happy with the grandparents. So the Supreme Court said we are not disturbing it. But when I did a matter recently in the High Court where one child was left with the grandparents, and the mother moved to a foreign country, and the father, on coming to know, wanted the child back. The High Court said, yes, you have to. The child told the grandparents, you have to return the child to the father. He's the natural guardian. The lady lost. She went to Supreme Court, and the Supreme Court has affirmed the High Court view. Now the point is, unless and until the father or the mother is declared unfit under the Guardian and Wards Act, the father or the mother cannot be deprived of the custody of the child. Now, if there are extenuating circumstances whereby, like Neil Ratan Kundu, the father or the mother is not entitled to the custody of the child, then the custody can go. I was an amicus in a matter in North India where a lady had died in very mysterious circumstances, and the two children, were taken away by their maternal grandmother. And the father tried all kinds of things, but the court said no, the girls are happy with the grandmother. So there is no hard and fast rule. It is a case to case basis decision on the best interest and welfare of the child. That is what I told you. We have no rigid formulas now, no gender bias, no parental, grandparental preference. It's, I think, the best interest of the child.
Oh, okay, sir. One last question from my side. Like in matters of sole custody, how can courts effectively address the recurring issue where one parent persistently violates the other person's visitation rights, as you already mentioned in this session?
See, it's a bad fight. You need very aggressive lawyers. You need persistent push. You need a lot of emphasis. I have handled a matter for relocation of 2 children to the US. 3 rounds of litigation from family court to High Court to Supreme Court. It took 3 years. Ultimately, these children got to go back. One child was born here. Things worked out, but one parent was very reluctant to go. It's a very, I mean, you have to be literally involved in the case. You have to be married to the case to push it. You can't handle litigation, complex child custody litigation cross border, unless you are in the case and with the case and on the case all the time. It's a difficult job. And see, the question is presence in India, money, sustenance for litigation, handling multiple petitions. It's a very multi law complex issue. Domestic Violence Act, Criminal Procedure Code, matrimonial cruelty, domestic violence, endless. We have to crystallize all this, and we have to drastically, on a revolutionary basis, amend the Guardian and Wards Act. Till then, I think we will remain where we are. Next, please.
Hello.
Yes.
Good
Yes,
evening, sir. Am I audible?
yes, you're audible and visible. Please tell me your
Thank
question.
you. Sir, my question is a bit situational. Suppose a couple is with having no issue and they have adopted a child. It's a boy. And after a few 2-3 years of their marriage, they are separated, but not legally. The wife went back to her paternal home, and husband is got married again without giving her divorce. But that boy who was adopted, he was sent back to his biological parents.
By whom?
And by father, because
By
mother,
adopted father.
pardon,
By
yes, adopted. Ji, ji.
But then if
And
you wanting to know what are the rights of the adopted mother, right?
ji. And now, as mother, when she adopted that child, she had some paternal property with her. Now, my question is, either the child has some right on her property because he is not living with them, and
This will all depend on how the adoption took place. Was there a deed of adoption or was it a Hindu adoption?
it was legally Hindu adoption.
See, under the Hindu Adoption and Maintenance Act, child is given, child is taken. You don't even need to write a deed of adoption. Child severs all ties with
Ji.
biological family. But the important,
Mhm.
the child should have been given and taken by the adoptive parents and the natural parents properly.
Hmm.
No proper,
Ji, sir.
then the adoption is not according to Hindu law, and that will make the rights insecure. So, if the adoption is irreversible, the child has severed all ties with the biological family and he has rights with the adoptive family. And the mother who has adopted the child can go to the family court or she can even go in a writ to seek the custody of the child. But everything will depend on where the child wants to be, with the adoptive mother or the biological mother or parents. So it's a mix.
Right, sir.
It needs tactful handling with situation on ground. Can be,
Either he. Hmm.
you can get in touch with me through the organizers. You can have my number. You can contact me wherever the situation is. It can be looked into and it can be resolved.
Hmm. Can he ask for the property of his mother after when he is of 18 years?
He has to ask for the property of the mother. I
Mhm.
don't know who else can ask. I don't even know whether he has a right. The boy has to ask, the adopted boy. Somebody
Okay.
cannot be used as a conduit for getting to the property.
Hmm. Because he is still legally adopted child.
Of course, he is. But then he has to exert his rights himself.
Okay. Thank you, sir. Thank you. Got it.
Anybody else?
Uh,
Yes, G. What
Sir,
about child living in relations? Is that it?
yes, sir. We can take the last question and then so yeah, over to you, sir.
So, what is the relations? Child living in live-in relationships, best interest and welfare. So, under the Domestic Violence Act, it is not called live-in. It is called relationship in the nature of marriage. The word live-in is a refined word, means the same thing. So, under the Domestic Violence Act, Domestic Violence Protection of Women Against Violence Act, there are provisions of custody, there are provisions of maintenance, there are provisions of shared household, etc. So, custody can be sought under the DV Act in children for children born in relationship in the nature of marriage. Under the Hindu laws, child is not called illegitimate. It's not a phrase to be used. Child has equal rights. It's not the fault of the child. So custody can be determined again on the welfare of the child.
uh, Thank you so much, sir. And on behalf of the organizing committee, I extend a sincere gratitude to you, sir. Thank you so much, sir, not only for accepting our invitation, but also for taking the time to guide and inspire all the participants. Thank you so much, sir.
Thank you. Thank you very much.